Good evening. My name is Carlos Moore, and it's my great pleasure to bring you greetings as the 79th President of the National Bar Association. I would be remiss if I did not wish each of you a happy new year. I'm wishing you and your families joy, happiness, peace, love, and prosperity during this year. This is a new year, a new season, a new beginning, and I wish everyone well. But there is a fierce urgency of now, so we're starting this year off with this voting rights panel, a primer, because we're going to be advocating in Washington, D.C. until we get the successful passage of a voting rights bill, whether or not it is the Freedom to Vote Act or the John Lewis Voting Rights Advancement Act. We have to have one or both of those, and we are not taking no for an answer. So we have to keep pounding the Senate. We have to keep pounding and advocating before the administration, the White House, advocating for them to do away with the filibuster so that we can get some type of relief in the voting rights arena. We just cannot have no for an answer. Our theme this year is Stand Up NBA, strong, tenacious advocacy for a new deal uplifting our people. And we are going to be strong and tenacious. We are relentless, and we are going to fight on behalf of the people that we represent. We represent 67,000 Black lawyers and judges, but more broadly, we represent the interests of the common Joe, Black Americans, African Americans, people of African descent living in America. We are here as their voice, and we are going to fight and stand for justice. And so we are pleased that Alicia Hughes, who's my chief policy advisor, and her team has put together this primer, and we look forward to beating the pavement in Washington, D.C. Later this month, in February and April, until we receive justice. And so again, it's my great pleasure as the 79th President of the National Bar Association to welcome you to this primer, and I know that you will get something out of it.
Perfect. Well, thank you so much for taking an opportunity to be with us this evening. And I echo President Moore's sentiments in saying Happy New Year to everyone. We are not going to belabor points. Today, we're looking at a presentation that says, listen, learn, and lead. We are preoccupied in the Moore administration and at the National Bar Association with the fierce urgency of now. So what we want to talk a little bit about is the legislative agenda and the impact of passing the federal John Lewis Voting Rights Act. And this is a constitutional primer, the reminder of why Black lawyers matter for holding the line with protecting the public. Kyle, could we advance the slides? Perfect. So what we have here with the National Bar Association with policy programming is we want to design and implement, and we have a bold, aggressive action plan that realizes President Moore's social justice agenda, educating people of all persuasions, but especially Blacks, on critical race issues affecting communities of color, while supporting and connecting activism at all levels and across all regions of our organization. Next slide, please. And what we have tonight is we've got a shop that's split with a journal on critical race issues. We have a policy, next slide, please, a policy and programming shop with a policy team that's led by me, a programming team led by Nalaja Ford, in addition to the journal. And our NBA Board of Governors and our Committee on Legislation has approved a platform that encompasses all of these issues: police brutality, election protection, which we're talking about tonight, criminal justice reform, reparations, which President Moore will be doing a panel on over the course of this weekend, economic parity, disrupting the school to prison pipeline, building wealth and wellness. Next slide, please. Tonight, what we're going to focus on is social justice, however. And what we recognize is the importance of these issues in promulgating them across the country, and how to engage and get a responsive approach, take a responsive approach to ensuring accountability. What we've got right now is the John Lewis Voting Rights Act that has passed in the United States House of Representatives, but we've got to hold the Senate accountable. And since the since the court decisions of Shelby County v. Holder in 2013 and Renovation versus DNC in 2021, there's been a constant erosion of voting rights across the country. There are so many different states that we could take a look at. There are 59 different legislative initiatives that have worked together to erode voting rights and voting protections as we would have them, and they disparately affect, in an adverse way, communities of color, and we're disenfranchising millions of voters. And without some type of corrective action, namely the United States Senate passing the John Lewis Voting Rights Act, we will go into a midterm election where we will see more disenfranchised voters than we've ever experienced in the history of American culture civilization. Next slide, please. So here we go, and I stand corrected, not 59, but 52. In 2021, 52 restrictive voter laws were passed in various states across our country, and they limited options on the right to vote and undermined local elections officials' ability to mind elections. Georgia's Senate Bill 202 is just one example, where they criminalized handing out water to voters who were standing in long lines. Yet and still, Georgia prevailed and elected Raphael Warnock. And then we've got Texas Senate Bill 1, which has would have election officials face prosecution for regulating poll watchers' inappropriate behavior in the polling place, amongst other things. Now, we are privileged tonight to have Judson Robinson III, former Vice Mayor Pro Tem of Harris County and president of the Urban League, who is leading the charge on a suit in federal court. Our own Laura Spencer, who's the editor of our NBA Journal on critical race issues, is one of the lawyers that signed that lawsuit. He's going to talk about how things are affected in Texas. We also are privileged to have with us Vice Chair of the Texas Legislative Black Caucus, Ron Reynolds. All of these folks are near and dear to my heart. I've got Texas roots, and he has done extraordinary work to the extent that we had members of the Texas State Legislature walk out of their districts, out of the state house, out of the state, to try to do their very best to hold the line to ensure that these draconian measures in Texas did not get signed into law, yet and still Governor Greg Abbott is that. We have him here with us tonight. We also have with us here tonight Gary Bledsoe. Gary Bledsoe has been the longstanding president or chair of the Texas Conference for the National Association for the Advancement of Colored People, who gets in a position and stays there for 30 years, a proud graduate of the University of Texas's law school and a stealth advocate for people of color all over the country and doing phenomenal work. And there is a state lawsuit that the NAACP is taking part of there in Texas to challenge the voting law there. And then we're privileged to have one of the youngest county attorneys in the modern history of the United States, and Christian Menifee out of Harris County, and he will make up the fourth member of the panel to have a conversation. We're looking at a case study for how Renovation versus the DNC, the 2021 decision by the United States Supreme Court, and Holder v. Shelby County, the 2013 case, has enabled state legislatures across the country to pass measures that will impact adversely millions and essentially disenfranchise them of American voters. Privileged to have along with me for the journey today a couple of friends. So this is something that's near and dear to our hearts. We've been friends for 20 years and colleagues. That panel I just mentioned is moderated by the lovely Patrice Willoughby, the former chief of staff to the late Congresswoman Stephanie Tubbs Jones. You all have the biographies of all of these phenomenal people. She's one of the most effective and longstanding lobbyists in Washington. And you'll just watch how she will pull things together with this panel and cause us to have a very robust discussion. And then after that, I'll give a primer on some other issues. And then we're gonna have Tammy Boyd, who happens to have been the legislative director to the late Congressman John Lewis, who ushered 3 key pieces of legislation, talk with us about how a bill becomes law and what our next steps are. I'm going to stop talking now because I want to get into the panel, but we have some slides that we will share, but I really want to focus on the discussion. with how sections 2, 3, and 5 of the Voting Rights Act have been adversely impacted based on Shelby County v. Holder. Kyle, do me a favor and advance a couple of these slides for me so that I can share this information. So we see what the problem is. One more time. Okay, so this is section 2 of the Voting Rights Act. No voting qualification or prerequisite to voting or standard practice or procedure shall be imposed or applied by any state or political subdivision in a manner which results in a denial or abridgment of the right of any citizen of the United States to vote on the account of race or color. And that has been expanded over the years, but that is the crux of section 2. Please advance to the next slide, please. Historically, there's been a very effective interplay, and I'm setting the stage for this panel, between sections 2, 4, and 5 of the Voting Rights Act. So until recent times, section 2 has worked especially well with 4 and 5 to ensure needed protections for historically disenfranchised voters. That's our people of color. Sections 4 and 5 created essentially a system that required jurisdictions with a history of discriminatory practices to submit changes in their voting and election laws to the Civil Rights Department or Division of the US DOJ for preclearance as non-discriminatory before these changes could take effect. The section 4 that set up a formula for determining which jurisdictions fell under the section 5 preclearance requirement that the Supreme Court unfortunately killed in great part in the 2013 case of Shelby County versus Holder, claiming it was based on an outdated evidence of discriminatory practices. Now, if you take a look at what happened in the insurrection on January 6th, the claims that we have faced as a country trying to invalidate the very real and legitimate election of Joe Biden and Kamala Harris, you have to stop to wonder whether the Supreme Court got it right. And I would venture to say we got it wrong. And I will stop here for just a second and pause. The National Bar Association is a nonpartisan organization of more than 65,000 legal professionals representing the interests of people of color all across the United States and abroad. We are not in favor of Democrat or Republican, we're in favor of causes. There is a such thing as right and there is a such thing as wrong. And regardless of your color, regardless of your affiliation, right is right and wrong is wrong. The right to vote is a fundamental right that is protected and guaranteed by the United States Constitution. And we uphold one man, one vote. So I wanted to make sure I got that in there before this conversation takes a slant. If it happens that conservative state legislatures are doing things to curtail one man, one vote, it may seem from time to time as though we're talking about the Democrats or the Republicans. No, what we're really talking about is the actors and what they're doing. And if those actors happen to be Democrats, they happen to be Democrats. If they happen to be Republicans, they happen to be Republicans. Unfortunately, it seems as though in states across the country where we have conservative legislatures in the majority, there are significant efforts to curtail the right to vote for everyone. Next slide, please. So let's talk about the Holder effect. The Supreme Court's decision, they held that the coverage formula set forth in Section 4B of the Voting Rights Act was unconstitutional. And as a consequence, no jurisdictions are now subject to the coverage formula in Section 4B or to Sections 4F4 and Section 5 of the Voting Rights Act. So accordingly, guidance information regarding determination of coverage under these sections, or the bailout provision as we call it, from certain acts of the special provisions for the Voting Rights Act are no longer necessary. Next slide. Let's talk about what RBG has to say, God rest her soul. Throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet. Next slide, please. So what we've managed to lose is we've managed to lose the prevention of voting changes being implemented until jurisdictions prove that they're not racially discriminatory. Next slide. Some of the examples of adverse impacts would be the voter ID card law in Texas post Shelby. Next slide. Next slide, redistricting in Texas, and I'm sure that Gary Bledsoe is going to talk a little bit about that. Next slide, please. One more slide. So we've got a Mississippi example, and these will all be posted to the NBA website. And the Renovation Fact. We've got some factors here. So it places significant limits on Section 2, one of the strongest voting rights tool in the arsenal since 2013. There is a 6-3 majority in Renovation that has offered a new and what seems to be impossible test that plaintiffs must now meet in order to ensure or establish a Section 2 vote denial claim. And there are 5 guideposts that Justice Alito, in his authoring opinion, offered for evaluation. And we'll talk about the John Lewis Act in its current iteration and what it does with or does not do with the Renovation factors that should not be a consideration, but I believe still are in the current contemplation. Next slide. So to talk about these guideposts and to set up the primer for the conversation and turn over the panel, he said the size of the voting burden imposed by a challenged voting rule or practice, noting that mere inconvenience is not enough to show a Section 2 violation. What about voting late? What about voting on weekends? What about opening more polling locations? What about extended early voting? Number 2, he said the degree of departure from the 1982 benchmark, the degree to which a voting rule departs from what has been standard practice at the time of this was amended in 82. When it comes down to the size of racial disparities from the election rules impact on members of different racial or ethnic groups, noting, and I quote, to the extent that minority and non-minority groups differ with respect to employment, wealth, and education, even neutral regulations, no matter how crafted, may well result in some predictable disparities in rates of voting noncompliance with voting rules. But the mere fact that there is some disparity in impact, and this is really important for civil rights and constitutional scholars, does not necessarily mean that a system is not equally open. That one stings a lot, okay? And I think that we can look at the strength of the state's interest served by the challenged voting rule or underlying challenge practice, noting that one strong and entirely legitimate state interest is the prevention of fraud. So let's look at the fact that there were claims that there was widespread voter fraud in Georgia and an effort to pin the election results in Georgia. And the results came out that it was not widespread. I think there may have had 5 cases in a state where millions of votes were cast. So this creates some problems. Next slide. Uh-oh. All right. So the consequences of applying these guideposts. This is a lax test, and as long as there are still some opportunities for minority citizens somehow, somewhere to vote, few laws could be deemed so burdensome that they would flunk the test. This is what creates the problem. I am going to stop talking now, ask Kyle, who is so phenomenal, to take this presentation down. I'm going to turn this over to Patrice Willoughby and the panel for a great discussion. And we'll come back and pick up on the back end about what the John Lewis Voting Rights Act can do and what we need to do to ensure that it's passed and what Black lawyers need to be doing to help millions of otherwise disenfranchised voters across the country and work alongside with all of the phenomenal civil rights organizations in this country doing the absolute best they can collectively, or we can collectively, and lobbying Congress and the United States Senate to do the right thing. Thank you so much.
Thank you, Alicia, and thank you everyone for being here. We are very fortunate to have such a distinguished panel today. And as Alicia has stated, We as Black lawyers have always had a significant responsibility in translating the legal decisions that are determined into specific on-the-ground activity that will protect the needs of our communities. And so we are so glad that you are here today, because we are here to translate what has gone on in the courts, what is currently going on in Congress, into specific and actionable steps that we can take as a community to help people who are disenfranchised and in need of our support. We have Texas, a wonderful panel in Texas. Texas has been one of the ground zero of activity in the legislature. And I would like to open with a question to the Urban League. And the Urban League has been a plaintiff to lawsuits to protect voting rights within the state. I would like to get some background on what drew you into this fight on voting rights, and how you see this playing out within the state of Texas.
Well, first of all, let me thank all of you for having the Urban League's voice here at this important table of discussion. We have some 90 affiliates throughout the country that work together on common issues, but also the National Urban League, which helps to kind of direct and set our policy and to monitor these policies that are having adverse effects on communities of color throughout the country. So when we began discussion with the NAACP Legal Defense Fund, we reached out to the National Urban League to ensure that we were in step with the wishes of the National Urban League. We knew the answer to that question, of course, but we thought it important to make sure that our Washington Bureau was in lockstep with the Legal Defense Fund to ensure that we're working as efficiently and as seamlessly as possible, and putting all the resources to bear that can help to push back on some of these voter suppression laws. At the time, we noticed that there was a rise in this type of activity. I think there were some 360 or so voter suppression laws that were floating around in the country in some 47 plus states. So when we lost Section 5, we began to see this onslaught, this rush to the table to push back on all the progress that's been made. So we really, Patrice did not have much choice. We spend a lot of our time on the response to policies that impact us. So we will have housing programs to help ensure that people who have been discriminated against can come to the Urban League and find ways to ensure that they have access to affordable housing. The same thing true for quality jobs. We know that there's discrimination that takes place, but the Urban League has programs to ensure that we can help those people who've been impacted by the various techniques and practices that exist in our workplace, in our housing structure, in our healthcare system, et cetera, et cetera. But this was one in which we needed to utilize our voice as well in a very proactive manner. And so we had no choice. I remember as a young man, the sacrifices of the 60s generation. Aljanita Scott Davis, a great dear friend of mine, and my auntie, very involved with the National Bar and the bar associations throughout the country, and has fought for ensuring that judges had access to the bench so that we could be fairly judged upon. So, I mean, I've seen it, I've been there, and when we were at the helm, as we are now, we simply could not take a step back, because this is not something that's going to go away. This is an orchestrated effort to push the clock back. So we have to educate, we have to fight, and that's what we're going to continue to do on this issue. And we stand with you. We stand completely with you.
I think that it would be really useful for our audience today to also have an update on the status of litigation. So would any of the panelists, for example, Ms. Ford, would you like to address the status of litigation, or Mr. Bledsoe?
I was going to defer to Ms. Ford. I think she is a counsel.
I was going to say, I was going to defer to
case.
Mr. Bledsoe. So go ahead, Mr. Bledsoe.
Okay, well, thank you all so much for inviting the NAACP to be part of this. I'm an NBA member and glad to see the NBA being so so much involved in this, because the NBA is a large part of any potential solution. Let me, before I go into the litigation, I'd like to give one basic factual backdrop that I think puts everything in perspective. Texas is ground zero, as Professor Hughes indicated earlier, and Texas is ground zero for a number of reasons, but there are a couple of characteristics about Texas that are in many ways a precursor of things to come nationally. In 2010, the census indicated that African Americans and Latinos were 49.4% of the adult population in Texas. And when you limited that to the citizen adult population, it was still 39.3%. As we sit now after the 2020 census, Texas is 59% minority when you add Asians, American Indians, etc., to the numbers. So the white population is really dwindling. So what's occurring in Texas is that there was an onslaught of laws that would make you think you're back in 1923 when Texas passed the law preventing blacks from voting in the Democratic primary. The breadth of the laws is pretty astounding in terms of the things that were actually done. I think I want to focus on just briefly the electoral changes that were made, the voter suppression laws that were introduced that we are now litigating. We filed a lawsuit in state court in Harris County. I think the other organizations that filed did file in federal court. We know that with the issues relating to Brnovich and the issues relating to the Fifth Circuit, based on the Trump appointments, we thought it would be worth at least trying to see what the alternatives might provide in state court. We filed a lawsuit where the Lawyers Committee for Civil Rights Under Law is lead counsel for the NAA, but a number of us are counsel along with them. One thing that is very interesting in our case is that in Texas, they have a provision in the rules of procedure that allow you to dismiss a case up front if you haven't pled a cause of action. It's a Rule 90. It's similar to the 12b-6 in federal court. The state has filed such a motion, but interestingly enough, the National Republican Party, the California Republican Party, the Texas Republican Party, the Harris County Republican Party, and the Dallas County Republican Party have all sought to intervene in our case. So we've drawn a lot of attention from a number of individuals. We have responded to their motion, and we're awaiting a decision from the trial court on the motion that was filed in that case. But I think that there's so much opportunity for all of you out there to help, because I think that if we understand the fears that people are responding to, and we understand what's likely to occur this cycle in 2022, we'll realize that the legal community is a big part for trying to be some kind of stopgap to prevent the continued loss of rights for individuals in our country. But you know, and just finally, in some, what they did in Texas in reference to the election changes that were made was extremely comprehensive and probative. It included everything from voter registration, enabling more voter purges, all those things that could be used to limit who's actually eligible to vote. And then the voter intimidation activities with all of these new criminal laws that were actually filed, the clear and overt indication that they're coming after individuals of Latino descent who may have become citizens. The efforts to provide new laws that will be used to discourage voters are huge. But even new electoral laws that will impact the NAACP and other organizations that try to get the vote out, because they're if you mention the name of an individual that you are supporting or you're wanting to actually see get elected for whatever reason that might be, and the individual you speak with has an absentee ballot in hand, then you've just committed a crime potentially. And so I think you look at things like that, and they're truly problematic. As you proceed on, there are many laws that require the execution of affidavits. They're trying to discourage people from being able to qualify for mail-in ballots. There's a requirement for providing personal identifying information to get mail-in ballots when that was not required in the past. There's a requirement when you assist a voter that you actually swear that you know the voter qualifies under the law to receive assistance. That's really intimidating for someone who simply wants to be a good Samaritan and assist someone. If you drive 7 people or more to the polls, there's documentation you have to fill out. If you assist a disabled voter, you have to put information that will be possibly contradictory, hopefully not, but people just sometimes don't communicate well. But you can all of a sudden see where you become the enemy of the person who votes instead of the friend, as you may have sought, because they will be comparing affidavits or what's actually said. The poll watchers are a major problem for African Americans in Texas. They have made poll watchers large and in charge. Racist poll watchers have been sent to minority communities for many, many years. This past year, the African American election judges did such a tremendous job at keeping them in bay. So many of the right-wing bigoted poll watchers refused to wear masks. And so they didn't let them just wreak havoc in the minority community. So they now have a law that makes them allow them to come in with masks, makes them get up to you as close as they wish to get to you, because they determine how close they need to be to see and hear. And so it's really crippled the ability of the election judges, and they can go to jail for interfering, for even telling a poll watcher that they have to keep an assured clear distance from a voter. For example, say you need to be 6 feet away, you can't do that anymore. So it's really incredible what they have actually done, but it goes on and on through the whole process of how you count votes and providing more opportunities to disqualify or invalidate votes, making sure that the extreme right-wingers not only will be poll watchers, but they will now be put on early vote balloting boards or boards that will count the actual ballots at the end and determine whether or not the signatures are matching signatures to the ones that are in their possession. And that's huge. So we're concerned. We know what they've done here with Crystal Mason and Hervis Rogers and others in terms of indicting people and then trying to display them to the community so they can discourage African American voters. And with all the new laws that are at play, we're going to need people to defend election judges, people to be parts of strategy. We need lawyers to actually be out there and to be part of the early vote balloting boards, et cetera, as well as filing the lawsuits and working with us to provide the kind of support that we're going to need, because there's an all-out onslaught. I think that if many of you have followed what's occurring, I think many people have determined that indeed they would rather not have a democracy than to share power with Black and brown people. So that's what's actually at stake. So we're in a very difficult time, and I think that that lawyers can and will make a difference, but it won't be the traditional way that we've done it. We're going to have to think of new and different ways, because right now, in my opinion, and I'm probably not the one to say this, but I don't know how much law truly matters. We've got to be able to reach somehow down deep to understand where there might be some of these judges that are in the right places, that there's something that they will not allow. That's kind of what Bernabik says. And I was so sad to see that Alito wrote the opinion. And so I think they were sending a signal by designating Alito to write the majority opinion. But anyway, thank you guys for having this. I want to encourage everyone to be active in your communities and work with your NAACPs, your urban leagues, and other entities that are out there to try to fight this, because what's occurring in Texas now is definitely going to be coming to your states, especially if you don't live in a blue state.
Exactly. And what we have seen across the states is that as our grassroots organizations and as our civic and social and our churches have become more deeply involved in getting people to the polls, these laws across the country are directly addressed at the specific measures that we have taken to ensure that people who have less access to the polls are prohibited and barred from participating. And so that is how granular these activities are, and the attempt to enshrine them into law. I'm going to direct the next question to Mr. Menifee and Mr. Reynolds, because I think that as we concluded the census in the past year, that reapportionment is very important. It has an effect on both local and national elected officials. And so I'd love for you to address that in Texas, particularly with the demographic changes which have been indicated.
I guess I'll go first. Let me just say good evening. I am so excited to be on such a distinguished, what I would consider an all-star panel. And the President Moore set the tone right, along with Professor Hughes, that we are dealing with the fierce urgency of now. And I know, just like the Honorable Justin Robinson from the Urban League was saying, that basically we all stand on the shoulders of those who paved the way for us, that led to ending Jim Crow laws that prevented Black and brown people from voting. And so lest we forget that we once had to deal with poll taxes and literacy tests. And it wasn't just that long ago, but it was the nucleus of the organizations that you see here. Great lawyers like Thurgood Marshall and others from the NAACP and the National Bar Association, and great leaders from the National NAACP and the National Urban League that led to those tremendous rights that we hold dear today. And shame on people because of a big lie trying to reverse back the clock to dark days. No, we won't go back to Jim Crow 2.0. So thank you, NBA, for hosting this. And I'll be succinct in what you asked me, because I had to get that off my chest, because I see right now an erosion. I see people turn over in their graves that gave their lives to freedom and liberty, so that we can have and protect the freedom to vote. The most fundamental right that we have is the right to vote in this country. That is what separates us from other countries that are ruled by dictators. And so we won't go back, and we won't stay silent. We're gonna keep making good trouble. This last census showed us in Texas, for example, that 95% of the growth in this state over the last decade was because of Black and brown people. Texas is now a majority minority state, and yet we have a majority in the legislature that disenfranchised those 95% by creating opportunity districts for Anglos. Again, 95% growth, Black and brown, yet there was no African-American opportunity seats, no Asian American opportunity seats, no Hispanic opportunity seats when we reapportioned because of redistricting. We were the only state that were gained a tremendous population, and yet and still, because of that diversity, and yet and still, when it came to redistricting, they did everything they could with almost surgical precision to pack and crack. And that's why I'm very thankful for the lawsuits of the NAACP, of the Urban League. I'm so thankful that the U.S. Department of Justice decided to intervene and sue the state of Texas, because Texas, unfortunately, because of the laws that Professor Hughes talked about from the U.S. Supreme Court in the Shelby, was one of the states that needed preclearance because we had a long history. Where I am from Fort Bend County, we had whites only primaries. And it wasn't until recently that that was struck down to allow me as the first African-American state representative in Fort Bend County since Reconstruction. So it wasn't that long ago. And here we are in 2021, where because there's no preclearance, my colleagues, many of who are emboldened because of that, they drew these districts to disenfranchise communities of color. So yes, we have to continue to speak out. We have to make sure that we impress upon the nation that we all have to be on the right side of history, that we cannot go back to those dark days of closing our eyes and say, well, this doesn't impact me, or if it allows my party to stay in power. We have to be statesmen and do whatever it takes to protect our democracy by protecting our vote. Because if we don't, we're going to see erosions in this country, the likes of which we haven't seen since the Civil War. So I'm hopeful and I'm optimistic. I'm prayerful, but my faith teaches me that faith without works is dead. So I'm looking forward to working with each and every one of you to continue to implore Congress, particularly the United States Senate, to pass the For the People Act and the John Lewis Voting Rights Advancement Act so that we can protect the fundamental precious right to vote.
Thank you so much. I'm going to wrap to what Mr. Bledsoe said earlier, in that we will get into this later in terms of specific actionable steps. As attorneys, we have always worked on election protection, but we have a number of tranches of work, one being advocacy of federal officials, one being the continued engagement on election protection, and then another being our work as specific, brain power and leveraging our collective ability to file lawsuits. And so those are going to be the three areas in which we will focus on later. But I will turn to Mr. Menifee to see if you would like to add in to what Mr. Reynolds has said. Oh, Mr. Menifee, we're not able to hear you.
Can you hear me now?
We can hear you now, yes.
All right, awesome. Okay, thank you very much, Patrice, for turning it over. And, I want to kind of piggyback on some of the earlier comments that were made. So I'm Christian Menifee, the Harris County Attorney. My position is unique in that I'm the Chief Civil Legal Officer for Harris County. And as many of you know, Harris County is the third most populous county in the country, more populous than 25 states. So we're in like this interesting position of, I represent all the county elected officials when they get sued, but we also have some authority to file lawsuits on behalf of the greater good of Harris County. And we've kind of been knee deep in these issues surrounding voter restrictions that have been passed by the Texas legislature. Dean Bledsoe was talking earlier about some of the lawsuits that the NAACP has filed. Well, my office has had the really unique perspective of being on both sides of these lawsuits. So there was a Fifth Circuit case not too long ago that effectively required voting rights advocates to, when they want to challenge a voting restriction, they don't just sue the Secretary of State or some other state official, but in some instances, they have to sue all of the individual counties, right? And so what voting rights advocates, including, the NAACP Legal Defense Fund, Mr. Elias and his group over at the new firm that he started, what they found out it was pretty smart to do was they have now started filing their lawsuits against us, which is ideal because we agree with them on all the policy issues, right? And so what that does is it allows the plaintiffs groups to be on, the side of righteousness, the defendants, us in the case, to argue alongside them on the side of righteousness. And then the state, generally intervenes in these cases to try to defend whatever onerous and repressive laws out there. And so it gives us, sort of a 2 versus 1 opportunity. And I think it's been really helpful to approach these issues from that perspective. But in addition to that, we have sued the state of Texas. Representative Ron Reynolds spoke a little bit earlier about the laws that were passed out here, as did some of the previous speakers. But one of the most outrageous things about SB 1, which was the omnibus election law that was passed out here, is it places new criminal penalties on elections officials and workers if they in any way educate and encourage folks on exercising their right to vote by mail. And the reason this is important is, all the data shows that vote by mail is disproportionately used by minority communities. In a lot of seniors' homes, especially in lower income communities and in Black and brown communities, you have folks in these communities who rely very much on vote by mail. But you also have folks who are kind of new to this pool who don't understand or haven't yet been made aware of the opportunities to participate in the process in voting by mail. And so what we saw in Harris County was there was a young brother actually who served as Harris County clerk, and he wanted to send out unsolicited mail ballot applications to all registered voters in Harris County. Started a huge fight between the state and local government, but suffice it to say, the law that was recently passed is now designed to penalize elections officials if they encourage folks to vote by mail. So for example, it could be a crime for our elections administrator to tell, an African-American woman who's 70 years old, hey, you can vote by mail, you should consider it, right? And they wrote the language so broadly that we think there are some pretty clear First Amendment issues. And so we have filed a lawsuit on behalf of our elections administrator challenging that law, suing the state. So we're in this weird position of we're defendant in some cases, but still siding with the plaintiffs. We're plaintiff in some other cases, but still doing what we can to fight the good fight from those perspectives. The other thing I wanted to quickly mention was on the reapportionment piece and redistricting. What we saw down here in the state of Texas was in the first round of maps that were put out by the majority party in Austin, they tried to combine 2 African-American United States representatives in the same district. And of course, that was a big problem because one of those representatives has been in Congress, is a very seasoned representative, and they're both highly respected. But in the state of Texas, we don't have, although population-wise, we account for, a nice plurality or subset of the population, we do not have a large number of reps. And so, to me, that was very obviously sending a clear message that the goal here is to minimize the representation in your community. And Representative Reynolds, Dean Bledsoe, and many others got involved in the effort to try to undo that. And ultimately, the maps were redrawn in order to separate the 9th Congressional District, again, from the 18th Congressional District. But it was a big fight that we should have never had to have, right? And it was done solely, I would say, to send a message about minimizing representation. But the other important thing here is because the United States Supreme Court has said that partisan gerrymandering is effectively fair game, you have seen state legislators across the country, but predominantly in states of a certain party that are led by folks of a certain party, you've seen extreme partisan gerrymandering, right? That if you just kind of wash the sheen off a little bit, it's very obviously racial gerrymandering, right? But they work backwards in setting partisan goals and aims so that they can withstand scrutiny in the courts. And this is just generally bad for democracy because for several reasons. One, the most obvious, right, is gerrymandering in any system to benefit a certain political party or a certain ethnicity is just morally wrong. But also what it does is it creates a tit for tat, right? You have this party at the state level is running things and they're going to gerrymander for their party. So they exhaustively gerrymander in their maps. And then you have local governments, which are run by a different party, tend to try to gerrymander in the other direction. So it's created a ton of perverse incentives that have now effectively turned map drawing into nothing but a power grab, which is really a sad and a shameful feat. And the last thing that I wanted to mention was, we've seen the Shelby County case, the Bridovich case. Effectively, what I draw from all of that is the United States Supreme Court has been very clear that they intend to kill disparate impact causes of action, that they intend to allow the states to go as far as they want to go in enacting voting restrictions. And we've seen restrictions no place more onerous than in the state of Texas. But what I try to convey to folks here on the ground is that it's important to, one, advocate for these things at the state level, two, advocate for increased protections. We're going to talk about that a little bit later at the federal level, but three, to take it to the courts. You know, some of the greatest civil rights battles in the history of this country have the initial battles were won at the courts. And so, you know, in my position as a lawyer who is an elected lawyer, we're doing everything we can to continue to try to fight those fights in the courtroom. And so I'm very pleased and honored to be on this call with a bunch of other lawyers so we can rope all y'all into the game as well and do what we can to advocate for our communities.
Thank you so much. We are going to shift in a moment toward our specific actionable steps. I would like to let our audience participants know that if you have a question, you should put it in the Q&A. We are also monitoring the chat. And I do have two questions that have popped up in the Q&A and chat that I will specifically address to Mr. Robinson and Mr. Bledsoe. And they are directly related, because one of the issues, of course, in getting people to the polls is the disconnect often where there is not representation of African Americans that they can specifically connect with to vote, and convincing people that it is worthwhile to vote. It was reported, one of our writers says that that what was the problem in getting 59% of people of color to the polls to vote against passage of the laws that are now supporting voting rights erosion. And then also from the Q&A, how are we able to get greater support in rural areas from organizations where we do not have effective representation or a lot of contact with those communities that are disinclined to vote?
Patrice?
Yes.
This is Alicia, and I'll turn my camera on. And I apologize, I am not a panelist, but I love this question so much, and I think that I might be able to help. Representative Reynolds. Representative Reynolds. Let me say this in Texas, something that I know, and I saw a comment on Facebook of all places quite some time ago. Representative Reynolds is in Houston. Well, he's in Fort Bend County, the first Black representative of Sienna Plantation folks since Reconstruction. But there's a gentleman who I'm near certain is on this webinar by the name of Robert Williams that does not live in his district, but he goes to Austin often, and he will tell you that his adopted representative happens to be Texas State Legislator Ron Reynolds. What I would say to our participant in the chat is reach out to him and other members of that Texas Legislative Black Caucus. It is one of the most responsive caucuses I've seen in the country. And I'm imagining someone is going to second me saying that. But when I know that there are people who come from districts that have a situation just very similar to what she's describing, and to know about constituent outreach, I'm just going to say go outside of yours and think back on my experience working for Bill Richardson when he was the only Democrat in New Mexico. And New Mexico, Dems from all over the state would write to our office and he would respond. I just say you have to go outside of that swath to get what you need. And I will not interfere with your panel anymore, but I just couldn't pass that.
No, that's an excellent point. That is an excellent point. Would Mr. Bledsoe and Mr. Robinson like to add additional comments?
I'll be brief. I think Gary can take a much deeper dive than I, but you know, we've just got to do a better job of getting out to vote. The question is legit. You know, 71% of eligible white voters voted. A little less than 54% of African Americans or our people of non-color participated. But the election itself, we had record voter turnout in the presidential 2020 election. But that's not saying anything unless we can get, again, that 58% of our people to be increased. You can't have record turnout and still be outvoted by the other interests that are out there. So, we've got to find ways. One of the things that we're going to do at the Urban League is we've created the Center for Social Justice and Education, because we understand how important it is to really educate voters about that very question that just came in. How can we lose the election when we have this great turnout? Well, the other team had better great turnout. So you've just got to, make sure that you are engaged at the level where people have a great understanding that elections matter, and every election matters, because once people are elected, then their journey up the ladder begins. So what we've got to do is ensure that the people that we want to climb the ladder are the people that we're voting for, that get elected, that represent our interests.
I would agree with everything that's been said, but I do want to go back to what Professor Hughes indicated earlier and say that our Legislative Bloc Caucus is a tremendous caucus in Texas. The untold story is that they were probably the leaders of the movement for the legislators to walk out and to deny a quorum. I'm just disappointed that the folks in Washington did not, in my opinion, give them enough respect to move a lot quicker on voting rights reform, because they couldn't stay up there forever. But I think it was really courageous, and Rep. Reynolds and Jarvis Johnson, Nicole Collier, all of them were really crucial. And I don't it was more than just them, but Gina Hinojosa from the Mexican American Legislative Caucus was really crucial too. But they're the untold heroes. I know that sometimes the networks claim other people were responsible for the walkout, but that's not actually accurate. And so, they deserve triple kudos for the courage that it took to do what they did, and they're feeling repercussions now. And answering the question about our folks voting, let me mention one thing that I think is instructive. One of the experts that the NAACP and the African American congresspersons have had in Texas is one of the most esteemed political scientists in the country, Dr. Richard Murray. And what he testified to in our trial in 2017 was that since 2010, the most incorrigible, bigoted, extreme voters in Texas turn out at a rate of 85 to 90% in every election. 85 to 90% in every election. So that 71% figure that Judson was talking about earlier is a little bit skewed, because the most extreme and incorrigible make up a huge number. And so you can imagine what percentage they make up in a Republican primary. And according to Dr. Murray, the two most important factors that were driving that level of voting were the election of Barack Obama to the presidency and their concerns about Latino immigration. But those two issues drive people to where they are going to vote. So one thing is, we need to let our folks know that the people that are voting mean us harm. But what do we need to? Well, we need to have more revenue and interest put into our communities. I think that sometimes people put money into campaigns, even nonpartisan campaigns in other areas, and they always say, well, Black folk are going to vote one way, so we don't put any money in the Black community. And that's a problem. But like what County Attorney Menifee said, and I just loved everything he said, but when we look at things on a local community and at a local level, we have to understand that we need to have support for the individuals who who were there. And in Harris County, they did the job. In Dallas County, they did the job. When you look at the black voter turnout in those two counties, it was really very high. I think it was equal to, if didn't exceed, the white voter turnout. And so I think this is a brilliant question, because the turnout was not as great otherwise, but the money is not put into those other areas. It's put into just a couple of areas. So we need to have more revenue. But the thing that we need to do, because our community is now under siege, is that we really need to make our voters feel safe and let them know that when they go to the polls, we're going to have their backs, and to let our election officials know that we're going to have their backs too. We don't, they're just looking for the next Hervis Rogers or the next Crystal Mason. Okay. They're using our people just to, as props, so they can go out there and intimidate our other folks from voting. That's what they do. And so we're going to need to be there large and in charge, because think about it. Now, we live in different areas, but if I'm a black person, Rep. Reynolds will tell you, if I'm a black person and I'm out there and I'm living in a rural community, I'm going to be a little bit concerned. And what Mr. Menifee can probably tell you is that they passed a law in Texas that is really incredible. What it does is it allows neighboring counties to bring charge election crimes in other counties that didn't occur in those counties. I think is unconstitutional, but that's what they're doing. Like, for example, if an African-American female sheriff in Jefferson County who's been charged with some nefarious felony charge, and she has had her case go all the way to the top criminal court in our state, where they went to Chambers County, a very well-known Confederate county, and indicted her in that county. So, that's the kind of thing that's actually going on. And Chris Wright voted at Texas Southern in Houston, but where they indict him? In Montgomery County. So we have some real issues here that we have to look at, and we're hoping that maybe we'll have judges that might follow the law. But there's been an incredible effort by officials in the state to really intimidate our judges, and they've done a pretty effective job at the highest level of our courts.
Patrice, if I could, just 30 seconds, really quickly.
Sure.
I would be remiss if I didn't personally give a big challenge to all the brothers out there, the men, because why do I say that? African women, Black women have been number one. They eclipse white men in terms of voter participation and voter turnout. So our sisters have been very engaged, voting in record numbers. Those numbers are skewed downward because of the lack of Black men voting. So I'm making a clarion call to the brothers that we have to step up our game and vote our values. You can't talk about criminal justice reforms and the brutal death and the disparities within our criminal justice system and wanting police reforms and George Floyd without talking about voting. You can't talk about the disparities and lack of healthcare and a livable wage of minimum wage and climate change and so many issues that really impact our community without talking about voting. So we need to raise our ante and vote our values. And I'm proud of our sisters from being consistent in voting. And I'm hoping that our brothers are going to step up our game. I'm going to do my part to reach out to my fraternity brothers, others, to vote in every election, not just when Obama's on the ballot, but every election is a critical election. And I want to thank Black women for raising the bar. And now it's time for us as Black men to make sure that we step up, to remember that we have to carry the torch and do our parts as well.
I think you're right in that in many cases it is only a Black man that can grab another Black man, particularly some of those men who are disconnected from the voting rights system, to get them to come to the polls and to make the case on why that's important. I'm going to, we've got a couple questions, then we will shift to Tammy Boyd, who has a really great presentation, which is the groundwork for some of the activity that we're going to ask everyone to participate in. But I have a general question for the panel, two of them actually. One concerning English language proficiency in Texas. And this is applicable across the country as well, wherever there are communities in which English might not be the first language for minority groups such as Latino, Vietnamese, or West African communities. Do you find that English language proficiency has been used as a proxy for discriminating against these minority groups? And then secondly, it's also related to efforts to discourage younger voters. And how can we ensure that 17, 18-year-olds are being given the opportunity to register to vote? And this is open to anyone. Well, I'm going to do what they do in the church and say, well, seeing none, what we will do is we will table those questions, and as a follow-up, we will see if there's some information that we can get out to our audience members who raised those issues. I'd now like to turn to Tammy. Oh, go ahead, Professor.
Sorry, before you do that, on the question about, and I told myself writing it down, so let me pull it up again. I'm not on the panel, but how do we, well, now I'm not looking at the question, but insofar as the language and language being used as a barrier, there were provisions put into Section 4 of the Voting Rights Act to address this very thing. But what we have now as a result of what is going on is there is a STEMI, there is a stifle, and that is part of what we need the John Lewis Voting Rights Act enacted in order to ensure we have protections against. Right now, people falling in these categories with language, well, English as a second language, we are running into some issues. So while there is a requirement under federal law now that you provide instructions in multiple languages, to the extent that it is not enforced, and it seems to me to be a secondary issue because it is not as prevalent or as easy to target as something that would be racially motivated. So looking at the skin color is one thing. Understanding the sound that comes out of the mouth on the other hand, and whether folks are discouraged from being present and simply walking away and not being able or not feeling as though they are empowered enough to state that they are not comfortable or able to finish a process. I don't think we get the complaint to the extent that the problem actually exists. And if the complaints are not coming through as prevalently, things are not being addressed in a manner as systemically as they should. And as a result, that's something that is falling under the radar. So I think that that's something that we have to, I can't say put in the back of our minds. I think we need to pull it to the front just a little bit more. But as a person that is historically, I lived and spent some time in Haiti, and definitely know folks who are West African, Vietnamese, they're not as quick to speak out. But that doesn't mean the issue doesn't exist. It's the squeaky wheel getting the attention, and it's not making a lot of noise. So I think that that's something that we all, as part of this community, wanting to make sure when we say people who would otherwise go unheard, we need to put something in our own mental psyche that says we need to put a check-in on this. So I think that it's not reported as prevalently as it should be, and things are going on far more than we probably are aware. We don't see newspaper articles oftentimes about this, but that doesn't mean it doesn't exist. So I think that that's something that we definitely need to be more attentive to collectively.
And this is also an opportunity for the type of coalition building with other bar organizations, for example,
Absolutely.
that might have insight into where, because communities are, and many families also have people of mixed status. And
Yeah.
so even though you have citizens who are eligible to vote, people may be reluctant because out of fear, particularly in the face of voter intimidation tactics.
Absolutely.
There was one question from a young person who asked about connecting if they're not in Texas. And what I would encourage is to stay in contact with your local chapters of the NAACP and the Urban League, as well as local elected officials, to tap into some of the protection efforts and others that might be going on in your community to protect the vote. But now I'd like to turn to Tammy Boyd. Tammy is going to give us a primer on legislative activity, which directly relates to the end of our presentation on specific activity of the National Bar Association and how we can all work together to advance voting rights.
And thank you for the invitation, Professor Hughes and President Moore, and thanks, Patrice, for moderating discussion and being here with this all-star panel. So we wanted to put this all into context from the legislative standpoint. When a year ago, a record number of voters led by Black and Brown voters, we turned out to elect change. And in the days and months since then, we have endured unprecedented attacks on our democracy and our efforts to suppress the right to vote. All while we've been promised reform legislation that has been sidelined. And so as Black lawyers, we really feel it is important for us to take action and call for the prioritization of voting rights. And so to move forward as a nation, we must ensure that every eligible American has the freedom to vote, and the results of our election reflect the will of the people. And as you know, today, states across the country are putting up new barriers to vote. In 2021 alone, more than 389 bills in 48 states, including high-profile bills in Arizona, Georgia, we've heard a lot about Texas, and elsewhere, have been introduced to restrict Americans' freedom to vote. And Kyle, if you can put up the slides. Okay. And so part of what we want to do, next slide, yes. So a part of what we want to do is just sort of level set, and we can go quickly. This is basic one-on-one, probably law school. How, just generally speaking, how does a bill become law? As we begin to advocate and cultivate for many of our lawyers as we go to Capitol Hill, we just want to level set again around how a bill becomes law. As you know, bill has to be is drafted, it's introduced in the House and the Senate, then it's referred to the committee, subcommittee, it's passed out, also then to the Rules Committee. And then from there, once the bill passes in the full Senate and the full House, there's a conference to make sure that the two bills and they can agree on that. And then it goes to the president for signing. Next slide. And that's just the general of how a bill becomes law. But then there's really, how does a bill become law? And there are several different ways and several strategic approaches that are happening behind the scenes. So for example, as we look at legislation, behind the scenes, there's negotiation of how the language actually looks. For example, with the voting rights, what pieces of the bill do we actually want in there? There are also lobbyists that are also advocating for their different interest groups and different pieces and different aspects of the legislation. Generating interest among legislators who support your issue. There's also coalition building, as Ms. Willoughby mentioned, coalition building, talking to other groups who have like-minded interests, such as the Voting Rights Act, and working with the NAACP and the Urban League. And then, just other strategies around passage. And then prioritize, and continuing to go back. We talked about the squeaky wheel, just continuing to ask for that legislation and applying pressure. And so one aspect of that, next slide. And so one aspect of that, and these have been mentioned in terms of, there are other aspects outside of the ones I mentioned, such as campaign contributions, lobbying, the grassroots campaign participation, fundraisers, et cetera, are also other aspects of the parts that you don't necessarily see that happen strategically around making sure a bill is passed. And the next slide. And then the general makeup of Congress, as you know, there's in the House, there's 221 now Democrats, and then there are 212 Republicans. There are 2 vacancies, one from Alcee Hastings, he recently passed away in 2021, and then also Devin Nunes, who resigned. And then there also for the Senate, there are 100. And as we know, which is where the voting rights, what's taking place now, what's at play is we have 50 senators and 50 Republicans, and there's a tie with the VP. And next slide. And so as we talk about voting rights, we also talk about, you've been hearing a lot in the recent in the news about President Biden we recently passed a big infrastructure bill, which is around sort of the environmental pieces, bridges, transportation, et cetera. And so now Black and brown voters, a large segment of the Democratic community, we're really pushing the same muscle that has been put behind the infrastructure bill. We want to also put that behind voting rights. And so this is now the time to really, and this webinar is coming at a great time because this is now the time to really apply the pressure. So for example, Senator Schumer, as you may have read, he sent a letter to his colleagues in the Senate saying, using the January 6th, the insurrection piece as sort of a basis of protecting our democracy and voting rights and the right to vote. It's being a part of that. And so there's some momentum. The King family will be coming to Washington, and they will say, before we can actually continue to celebrate MLK Day, we also need to be able to celebrate a passage of the Voting Rights Act. So that's a lot of the background of what you're hearing now in terms of the Voting Rights Act and applying pressure. And so why the NBA's voice and the Black lawyers, why this is so very important. And so then you're also hearing about the filibuster reform, and we'll have some of these slides on, I believe, Alicia, we'll have these slides online. But as you know, just quickly, what is the filibuster? And so the filibuster is a procedural tool that senators use to delay or block action on a bill they do not like. And under the rules of democracy, the support of a majority it's 50% plus 1 is usually enough to win. But these are the rules. These are the rules of the Senate when the bill comes to a vote. 51 senators voting together in support of the bill means it should pass. However, in the Senate, you've been hearing about the filibuster. And the filibuster works by requiring that a supermajority or 60 senators vote to end the debate on a bill and allow it to be voted on. And so some of the strategies that are happening, as we talked about, like how a bill becomes law, that's the basic part, right? But then we talk about some of the negotiations, and you're hearing about Manchin and Senator Sinema and why they are so important, or why in making sure we get to the number that we need to. And so the voting packages that are out there, as you know, the House has passed 3 different voting and ethics measures. There's HR 1, which one responding to the changes to the Voting Rights Act, HR 4, another on executive branch ethics and foreign election interferences, HR 5314. And so Democrats are attempting to really advance this in the Senate. And so that's why everyone is really focused on the Senate, because that is where Republicans are opposing what they say would be, there are several reasons why, but they're saying that would be a federal takeover of state matters. Next slide. Yes. And again, we just talked about filibuster, and later we can also go into even the history. Patrice and I were just talking about even the history of the filibuster. And when you start to read, it's really interesting because it has been used as a tool in the past to really block, legislation that really benefit African Americans and people of color. And so, it really is in terms of pushing back and saying, hey, we want to really encourage, and one of the call to action is encouraging Senator Schumer, the Senate, to put a filibuster in place, which then will allow us to push the Voting Rights Act through. And again, there are two really main bills, but the John Lewis Voting Rights Act, which you've been hearing a lot of, and what that is, it's a bill, and this is very top level, but it's a bill designed to restore the original Voting Rights Act of 1965, VRA. It would prevent legal challenges to voting rules that discriminate on the basis of race or ethnicity from being implemented, and will restore voters' ability to challenge discriminatory laws. And the John Lewis Act addresses the gap left by the Supreme Court in the 2013, as we've heard, the Shelby County v. Holder decision, by introducing a new pre-clearance formula that addresses modern discrimination tactics, such as poll closures. The bill also ensures that changes to voting rules that could discriminate against voters based on race or background are fairly reviewed, giving voters an equal voice nationwide. And lastly, and additionally, the John Lewis Voting Rights Act includes provisions to grant the Attorney General the authority to request the presence of federal observers where there is a serious threat of racial discrimination in voting and more. Next slide. Next slide. Thanks. So we talked about also the power of sort of collaborating with other groups. Yes, collaborating with other groups. So NBA should definitely, we should have our independent voice strategically. Black lawyers have always been a part of major movements such as this. But then there are also mobilizations that are also going on with faith leaders, civil rights leaders, voting rights advocates, and they're joining together to demand voting rights legislation. So as mentioned, there will be a march. Leaders are coming to Washington with the Martin Luther King family on the 15th, 16th, 17th. They're going to have demonstrations in Arizona, Georgia, and on the 17th, that will be in DC. And so in addition to also participating in this, and I believe we're going to also have one where 100 or 1,000 Black lawyers come to Washington to also advocate for this. NBA is also looking at joining different movements and collaborating with other coalitions. Next slide. And so in terms of next steps and what the NBA lawyers can do, I mean, we are submitting or working on amicus briefs. We're looking also at doing a Capitol Hill Day, and then also contacting what you can do right now on the call to action is calling your senator and telling them that we must eliminate the filibuster to protect our right to vote. And we'll have a number to show to you that you can call and voice that, and it will connect you directly to your senator. Wherever state you're from, you just say connect me to Senator X, and it will connect you. And then after this, we're going to also circulate a template letter that you can write in and email your senator as well. And then I know NBA will also be meeting with key leadership in the Senate to also address our support and then make sure that that the administration and also the Senate knows that we are supporting this effort. And again, we will continue to collaborate with leading organizations around voting rights advocacy. Next slide. And again, this is the telephone number that we have for you to call to reach out to your senator to tell them that we must eliminate the filibuster, protect our right to vote, and to pass the John Lewis Voting Rights Advancement Act. So it's 1-888-408-2349. And again, we will be following up with with a letter for you to send individually. We'll also be planning an advocacy day for NBA lawyers to specifically go to the Hill and advocate for the Voting Rights Act. And I can turn it back over to Alicia and Patrice.
Thank you so much, Tammy. And Kyle, I am going to beg you in a moment to put my slides back up. Tammy, can I get a head nod if you're able to hear me, so I'll make sure you can hear me? Okay, I am so grateful to everyone who has participated or is participating in this very timely and necessary discussion at this moment in time. Kyle, the slides at any time, and I want to just pick up where I left off, but I can take this opportunity without them to talk a little bit more. Tammy has dovetailed beautifully into what I want to talk about. What we've got is a situation where the votes that are necessary to get, this is a very fine dance. We've heard from folks in Texas on the front lines, because Texas is a very, very real case study, and it sets the tone for so many things that go on across the country at the state and local level. But what you have here, combined with an extraordinary panel of stealth advocates in Texas, is folks that I know firsthand to be experts based on maneuvering the Hill. Tammy is very, very gracious and very kind, but I would venture to tell you that as a legislative director for the late Congressman Lewis, for whom this Voting Rights Act is named right now, she actually did the bill that established that there are disparities in how Blacks are treated in healthcare. That study led to the Office of the Establishment of Minority Health, and then it took a very long time to fight to get a museum for African American heritage and culture. This is the staffer working for Congressman Lewis that did that bill and maneuvered through the House and the Senate to get it passed into law. So when she's telling you about the different options and things that are on the table and the games that are being played behind the scenes to get us to where we need to go, and I'm going to ask Gary Bledsoe before I get back to consequences, et cetera. We don't want to get to the point where the message is all over the place. You have to zero in on what it is that needs to be done, what we insist that you do, so that something actually gets done. The House has passed a version of the John Lewis Voting Rights Act. Now we have this bill that is in the Senate, so the one that is most likely to get signed into law, of all the things that are on the table, you see, it's that one. So what we've got right now is these Renovation Factors that we're talking about, these 5 factors. Justice Alito has gotten into this opinion, Supreme Court case. It's still there somewhat, these factors on the table in the Senate version that is being considered, but it is the closest thing that we have to ensuring that there are protections in place before the midterm election to ensure that we are not disenfranchising or allowing for the disenfranchisement of millions of American voters. We have an affirmative obligation, all of us collectively, to make this a go. Now, the National Bar Association, there are 80 organizations going into DC in January, and we had a conversation about this at the tail end of last year and approved our legislative agenda most recently. We stand in solidarity with all 80 of these activist and civil rights organizations. Sign us up for the Jubilee and the King family. But what we can't do is allow our legislators to make something in vogue and say, since this is Black History Month coming up, or since we've got these organizations coming, that now is the time for us to say we've got to eliminate the filibuster. We could have done it last year. So what we want to do as a National Bar Association is scaffold what is going on with other organizations, and separate and aside, we want to send a letter and be assured it's coming out in the clarion call from President Moore with the Stand Up NBA is a letter thanking Senate Majority Leader, thanking Mr. Schumer for the letter that he sent to his Democratic colleagues, saying that we must work to do something by, ironically, the date that all of these folks are showing up in DC. What we're going to tell you is if this is not taken care of, we are requesting meetings as members of the NBA, and if it's such that we have to do it virtually, we'll request virtual meetings. If you'll meet with us in person, we want to meet with you in person in February. We'll have 2 lobby days is what we're going for, to say we need you to pass this Voting Rights Act. If you can't get it done, don't worry, we'll be back in April. And what lawyers are good for doing, we support advocacy, but we're multidimensional folks. NBA members, we sue people and argue for a living. I'm just going to invite the consideration that we don't often get paid to do what we want to do, that we are passionate about. And it's the right thing to protect millions of American voters. We can't come up with a greater clarion call than this. And oh, by the way, if you sue folks under civil rights legislation or civil rights statutes, I think you collect attorney's fees for that. And I'm not saying I think, I'm telling you I know. So we literally need to get the John Lewis Voting Rights Act passed. It should be a priority. Because once that is passed, what we have the ability to do, and I'm talking off the script of my beautiful slides, is we have the ability, with the John Lewis Voting Rights Act passed, to go in and to challenge all of these 52 draconian measures that have passed based on conservative actions at the state and local level. File lawsuits, have those measures overturned and invalidated before the midterm elections. Patrice stated it right. Advocacy is a large part of what we do. Poll watching, poll monitoring, training, getting on the election hotline. We did that under the Hochler administration. I imagine it's coming back up again, and that was an election cycle. When President-elect Baker takes the helm of the National Bar Association, she does it walking into the midterm elections. It will be necessary to do all of those things yet again. Right now, advocacy and making sure that people in power know that we are going to show up with other organizations and then show up alone and pound the pavement, call, advocate, and sue until people are protected. That's what we're going to do. So the letter is going out. NBA members look forward to seeing it. It's coming this week, and we're asking you to write letters to your senators asking them to support breaking cloture, getting past this filibuster. This is a procedural hurdle, friends. It's a procedural hurdle that people need to expend political capital to get over so that this can come to the floor for a vote, because the votes are present in the Senate to pass it. It must pass in this Congress so that it can be signed into law. And oh, by the way, the sooner the better, because what you have to look at is everything goes on a cycle. We need it passed because guess what? After it's passed, it is the foundation for lawsuits that enable us to invalidate these measures. And oh, by the way, there's an expiration provision that sunset it on the 31st of December, and Gary Bledsoe can speak on this. So the version of the John Lewis Voting Rights Act that is being contemplated now needs to have amendments to ensure that it can retroactively apply to invalidate provisions of laws in states like Georgia and Texas to ensure that we're actually putting the protections back in place to protect voters that have been guaranteed by sections 2, 4, and 5 of the original Voting Rights Act as amended. So let me keep going. Kyle, next slide. And so what we have with Renovation, getting back to these two cases that we have to undo with the passage of the John Lewis Voting Rights Act. States don't have to prove fraud. Look at what happened in Georgia. Renovation now is a license to give tenuous excuses that conservative legislatures are increasingly likely to give in the era of the, as Representative Reynolds said, big lie, that the 2020 election was stolen from Trump. Let's go to the next slide. This just shows, and yes, Tammy is correct, we will post these on the NBA website, the textualist reading of Renovation. Very few challenges, so the law as it is now, due to Renovation and Shelby County v. Holder, is what I'm sharing with you now. Very few challenges to early voting and mail-in voting will succeed, and any burden imposed by the states on early voting or mail-in voting regulations will likely be seen as light. Challenges to relatively novel restrictions will more likely prevail, and future suits will almost certainly include detailed quantification of the magnitude of a voting practice's disparate racial impact, since the size of the disparity matters. And challenges should be stronger in states with lower turnout and or higher cost of voting, since states' entire electoral systems are now relevant. That's how a textualist will read this case, but that's just not the way this goes. Can you keep next slide, please? So, as I just stated before I got to this beautiful slide, democracy salvation, in the words of my colleague Steve Hockaday, that great city council president in Plainfield, New Jersey, we've got to save democracy. The salvation for democracy is the enactment of the John Lewis Voting Rights Act and getting that thing signed into law. Friends, a priority. We need this done in January. We need to tell them if it's not done in January, the lawyers are coming in February. If you ain't got it done in February, I'm sorry, we're coming back in April. And oh, by the way, we're going to be joining everybody's lawsuits. And we really would prefer to be suing folks, get this bill passed so that we literally can invalidate these measures well in advance of the midterm elections, because what we know will happen is this will get kicked back to the court. So legislative intent and federal law will trump a court's case law with these two cases. Next slide, please. So this just gives you an overview of the John Lewis Voting Rights Act and its impact. And you can take a look at your leisure. Next slide, please. It's essentially what I just said. And as I noted, ways to improve or considerations to change for what is being contemplated in the United States Senate at the time. Insisted retroactive application language be included to ensure that laws passed in states such as Georgia, Texas, Florida become invalidated upon enactment of this new federal law, and consider removing any consideration of the Renovation Factors when reviewing voting rights laws that will come forward. I think that's a sticking point for the likes of Manchin and Murkowski, who in the current form that is contemplated in the Senate, we've been made to understand are supportive if we can simply expend the political will. I will end on this note before taking any other questions and turning it back over to our phenomenal moderator, Patrice Willoughby. It is not lost on me. This is not a Democrat or a Republican issue. This is not a Black or a right issue. This is a right or a wrong issue. You are either on the right side of history or you are on the wrong side of history. And if you are not trying to ensure one man or woman, one vote, you are not on the right side of history. And we have to collectively stand and ensure that everyone's right to vote is protected. It is not lost on me that Joe Biden and Kamala Harris are in the White House based on what brown people did. There was a tide turning based on the words of one of our most senior members of the Congressional Black Caucus, Jim Clyburn. We've stayed away from this in this conversation, but based on the strength of his word, there was record turnout, State Representative Reynolds, as he's noted, Black women in South Carolina. It turned the tide in the Democratic primary, and that buoyed him right on into the White House. Now, we expended political capital to get something done because we wanted to believe that our government would be fair to all of us. If we were willing to expend that type of, not financial, but political capital, stand in long lines, vote in record numbers in order to ensure an outcome and to overcome all odds, it is not unreasonable to expect that our legislators will do what is necessary to protect what is most fundamental that goes back to amendments to the United States Constitution, Bloody Sunday, people fighting, bleeding, and dying for this right. This has to happen, and it is a fierce urgency of now. And when the NBA gets ready to go to Washington, do not believe for a New York second, we are not inviting the Texans, and let's whosoever will, let him and her come. Let's go together. Let's get the job done. We are with you 200% of the way. And I am really grateful to everyone who's participated. I'm turning this over and asking that Patrice, we go through the questions. Elijah Ford, our program director for the NBA policy and programming team, We're grateful for your assistance, and we could not have asked for a better panel to kick this off, and we're taking the show on the road. Thank you so very much. I will stop talking now and turn this back over to Ms. Willoughby. It is a privilege to sit in this position and to work with all of you.
Well, Professor, thank you so much. This has been, it's wonderful to be in such great company today. A couple of points. We have on our webinar today, Denise Rolark-Jones, who's the publisher of the Washington Informer. One of the things that we cannot forget in that, although we are all very digitally engaged, is that there are people in our community who continue to obtain their news and information from the Black press and from Black radio. The NNPA, the National Newspapers Association, which is the Black press, has recently engaged in a cooperative organization on digital engagement, but Ms. Jones is suggesting that people write op-eds and send them into their local Black press, delineating the importance of voting rights on a regular basis, because this really is now go time. And we know that older people read newspapers, younger people don't read them as much, but we really need to have every mode of communication in which to emphasize the importance of voting rights. The second thing from Ms. Boyd's presentation, the Senate number for senators, not only your senator, but there are senators that have large African-American populations that we know are not supportive of voting rights. And so after you have reached out to your senator, we'd encourage you to reach out to other senators as well, particularly those that we know are in support of eroding our rights and the rights of their significantly numbered constituents to vote, because this is not a Democrat or a Republican issue. It is an issue of democracy. I will pause here to see if there are any further questions.
And Ms. Willoughby, if we could give final words or closing words, if President Moore has anything he would like to say or add, and our distinguished panelists, I would be remiss if we did not give them the opportunity to close this out after we take a look at these questions. I thank you so much. All right. Okay, so can we ask our panelists to give us, President Moore, are you here? Or if not, moderator, can we go and get the closing remarks on this thing?
And I'm just going to chime in. Thank you so much, Alicia, for your presentation. Thank you to the panelists. You guys have done a wonderful job. I've sat back and listened, and I've literally learned so much, even being an active voter. And I'm so happy and ready to engage my community as well as others. And thank you for the skills and the lessons that you've taught during this presentation. So just wanted to say hello, I'm here. And thank you. Everybody have a wonderful evening.
Cheers.
Ms. Ford, thank you so much for your participation and your work on the lawsuits involving voting rights. With that having been said, we will continue to communicate. The decks that presented today will be on the NBA website, and we will be monitoring to see if there are other questions. If there are, you can feel free to reach out to the legislative committee, and we will do what we can to connect you with any entities within states to also ensure that there's good connectivity amongst the NBA as we press forward on voting rights. And with that, I will turn it back to the professor for any final remarks in closing.
And she is simply asking, and I will call them one at a time. I will tell you, I have long been a fan of Judson Robinson III and watched his work as a college student at Texas Southern University. And for him to be leading the charge with the Houston Urban League, it comes as no surprise that they would be on the front lines with a federal lawsuit. And Houston is just on fire. I would love for him to give us his closing thoughts, and then I'm going to ask for Mr. Bledsoe to give us his closing remarks, and I'll keep going down the line. We'll close it that way. And we'll do the very best we can. I will look through the chat and make sure that we get to the questions that are remaining outstanding. And policy@nationalbar.org is an email address that folks can have, and you can reach us that way. Mr. Robinson, please give us your closing thoughts. Thank you so much for being with us.
Alicia, thank you so much. And thank you to all of the membership of NBA and to the leadership as well. We are honored to be in the fight. I encourage everyone to get in the fight if you're not in it, and to stay in the fight even when you're not winning. It's important that you keep your chin up. This is not easy work, but it wasn't easy for our ancestors either. And they brought us a long way, and we owe it to them and to generations to come to ensure that we've done our part while we're standing on the mantle. Thank you so much for this opportunity tonight.
Thank you. Mr. Bledsoe?
Professor, thank you so much. And I want to applaud President Moore and the NBA and everyone who was on tonight. I simply want to say that we're on the precipice of possibly losing our democracy. And so it's going to be extremely important for all of us to stand up and to make sure that that doesn't happen. We have to understand that when we start looking at what happened, for example, on January 6th of last year, and you look at some of the studies that have been done and the analyses of the people who've been identified as some of the criminal participants, and you find that 52% of them owned businesses or were professionals who were doctors and lawyers. I think you can really understand the enormity of the gravity of what we're talking about. It used to be we were thinking about people who lived in the hills or maybe a few Klan members, but this is a whole different operation. And when you start looking at the opinion polls and the people who don't believe that the 2020 election outcome was a legitimate outcome, and you see where there are over 20 million Americans that have indicated recently in polling that they support violence to remedy the issue of the problem, and you understand where the FBI has indicated that domestic terrorism is probably the #1 threat to our constitutional liberties, we have to understand we're in a very different time. And so we're in one of those really difficult times in life, but we need you to be part of the solution and come and take part. Years ago when our community was fighting for an upheaval and to be included and to participate, what they did at the NAACP was they developed just a great arsenal of great lawyers around the country, NBA members, other members of local Black bar associations. And they were the ones that really were out there leading the efforts and the great litigation. Many of them, many folks don't know their names, but I know most of their names. And I know that they were so crucial and important. And we need you to be that kind of crucial and important and come and be with us, because right now we're at really a watershed moment. And it's going to be people like you that can come and make the difference, because as I said earlier, the other side is engaged. They have a plan and they're implementing that plan. And as Malcolm X once said, if you're not at the table, then you're probably on the menu. And so we have to understand we're not involved in their discussions. So we're probably on the menu, and we need to come together as a community and fight against the individuals who are seeking to take us back to Dred Scott in 1856. Thank you, Professor.
Thank you so much. And I'm going to ask Mr. Menifee to speak, and then we're going to ask Representative Reynolds to close us out. And before I do that, I would be remiss if I did not give my round of applause to Tammy Boyd and Patrice Willoughby. We've been friends since we were younger girls and colleagues working on Capitol Hill. I'll date us 20 years ago. So to just watch how things evolve over time, we have the collective sensibility, all of us together in our different dimensions, to bring this thing across the finish line, and I look forward to it. And Mr. Menifee, please, your remarks. We're so grateful to have you with us and so extraordinarily proud of you for being one of the youngest county attorneys in modern history of this country and the youngest in the history of Harris County. Big deal.
Thank you. Thank you so much. And I'm very grateful to be here and excited for the electricity that I feel from chatting with you all on this call. We have an uphill battle. I think I heard Dean Bledsoe kind of talk about this, but we're fighting these fights on all fronts. I mean, we have lawsuits to undo the draconian voting restriction laws that have been passed. We have lawsuits related to redistricting. We have lawsuits related to the new criminal penalties that they're trying to put on elections folks. You have advocacy groups representing the Black people in the state of Texas who are being prosecuted by DAs at the instruction of the Attorney General's office for unknowingly voting while ineligible. This is a fight that we're fighting on multiple fronts, and so to have lawyers, skilled advocates at the forefront of these fights, in the game on these issues, participating and putting those great skills to use is going to be incredibly valuable. I know that the work that Miles has tried to do and some of these other advocacy groups, especially the firms and the legal advocates, has been incredibly helpful. So to have more people fighting on those fronts is going to be very helpful to the cause, and I look forward to continuing to be in this fight alongside you. At least I can say this as somebody who's just over 30. In my lifetime, I don't think there's been a time where civil rights have so clearly been under attack from an institutional perspective, and it's been so veiled, right? If we sit back and allow these things to happen, we will have substantial changes in the way that we participate in the democratic process. This is not one of those things where 20 years from now, somebody's gonna say, oh, this is so egregious. It very much, if we don't fight these fights and we don't win in the courtroom and at the Senate, this can become a normalcy in our country. And so I encourage you all to get engaged in this fight, and I'm grateful that the NBA is providing an opportunity and avenue for folks to do so. I look forward to fighting alongside you.
Thank you so much. And my favorite state representative in the country, Representative Ron Reynolds. Take this.
Thank you. Thank you. I'm not going to be redundant. I just ditto and second and amen all the previous comments. And what I would add for the listeners is this. Many of you have watched football games and said, if I was the quarterback or if I was this, I would have done this, this, and that. Some of us have looked at doing Black History Month or doing others, the civil rights movement, and said, hey, if I was a part of this era, I would have done blah, 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 blah. I would have marched, I would have fought. Well, this is our civil rights moment.
It is.
Around to march with Dr. King or go to the back of the bus with Rosa Parks or be with Fannie Lou Hamer or Medgar Evers in Mississippi or so many others. But here we are in 2021. Each and every one of us can do our part. We can use whatever talents that God gave us to pay it forward as we stand on the shoulders of those who paved the way for us. And so I'm hoping that we will all rise to the occasion to make good and necessary trouble, as our dear brother who's looking down from heaven, I believe, John Lewis. And so all of us have a collective responsibility to do our part, to use God's gifts, to speak out for the least, the last, and the lost. To do as it says in Proverbs 31:8-9, to speak out for the one who cannot speak, for the rights of those who are doomed. Speak out, judge fairly, and defend the rights of those oppressed and needy people. So let's do our parts as Christians, as brothers and sisters in Christ, as Black professionals, as the talented 10th, as Du Bois called us, and to do our part for those who are underserved, who are marginalized, who far too often are discriminated, the last hired and the first fired. So this is our civil rights moment. This is our time to do what is best for our community. So thank you, NBA. Thank you to my dear sister, Professor Hughes, to these great attorneys, to the National Urban League, the Houston Area Urban League, to the National NAACP, to the Texas State NAACP, and for all of those who are willing to be on the right side of history and to fight the good fight. We will slay the giant Goliath with the faith and the tenacity of David. Thank you. God bless you.
Thank you so much. And that concludes. Tammy Boyd, do you have anything that you might like to add?
No, I agree with Patrice. Let's make some good trouble. So thank you so much for having us today.
Our pleasure. Take care and good night to everyone, and we'll be in touch soon. And thank you so much to the NBA staff. Kyle, you've done an outstanding job, and we're really grateful. We could not have put this together without you. We're only as good as the people that help us, and we could not have done this program without you. So we are indebted and immensely grateful. Thanks to all of you, and have a good night, and let's go make some trouble. Take care.